appeal in the matter of Stoute and Leather and Group Newspapers Ltd.
May it please your lordships, I appear on behalf of the appellants in this matter, witness for Victoria Jolliffe. My learned friends, Mr. Adam Wolanski of King's Counsel and Miss Hope Williams, appear on behalf of the respondent Group Newspapers. My lords, first of all, could I just bring your attention to the fact there's a reporting restriction in this claim, which you may or may not have noticed. It's set out at paragraph 13 of the core bundle. That is page 161. And you'll see the mischief of it is to stop the photographs being deployed in open court and visible to the public, because, of course, anything submitted in open court will be reportable with impunity.
Yes, so the normal cape and ring
yes.
arrangements don't apply until we've given our judgments.
Yes, yes, precisely. If I can then proceed directly with the matters on appeal, my proposed plan is, within the time frame of finishing by 1:45, to deal with the facts of this case, which of course are quite limited, the broad principles concerning the relevant law, and then to delve into the case law, which is reasonably limited, but fleshes out the principles more than adequately, we'd say. And then lastly, and of course most importantly, to go through the short judgment of Mr. Justice Johnson, identifying the errors of law and where he went plainly wrong in exercising his discretion or his decision-making process. If I could start with the facts, at the hearing before Mr. Justice Johnson, the only evidence put before the court were two witness statements given by the second claimant, Miss Sarah Stoute. The judge, as recorded in paragraph 2 of his judgment, took the facts from those witness statements. It's important to say that the defendant did not submit any evidence at that stage. This was important because the claimants had been pressing them for disclosure of the full set of photographs of what happened on the 27th and 28th of December, including the metadata, because that would have revealed better than personal recollection what had happened. And of course, the presence of metadata would give details of the type of lens used and the times the photographs were taken. Now, moving on, the introduction of a new case by the defendant by relying on the re-amended defence in the skeleton and putting the re-amended defence in the core bundle should be disregarded by the court because there's been no application to submit new evidence. And I think it's implicit in the way Mr. Wolanski introduces the re-amended defence in his skeleton that it can't be relevant to the matters before the court today. I'd also urge caution to the court in regard to other matters in which Mr. Wolanski in his skeleton argument makes certain factual allegations, which I'll come to shortly, which were in fact not in evidence before Mr. Justice Johnson. So proceeding to the brief facts of the case, or the factual
Before we go there,
yes.
could we have some citing of what's going on in these proceedings? Where have they got to?
They've got to the service of a draft re-amended defence on Friday afternoon.
Any hope of a trial?
Well, I should hope so. The next stage.
But when? I mean, this is not difficult. This is not difficult stuff. Why is it taking such a long time to?
Well, the next stage is the sending out of the allocation questionnaire by the court.
Right. So when in real life is this likely to be tried, if it ever gets to that point?
I can't answer that question, my lord.
Well, I'm going to hope that the combined.
I can ask.
Yeah. Well, I'm going to hope that the combined expertise present in court is going to give me at least a year, if not a month, when I might be expecting that a trial of this kind might take place.
Well, I'd hope later this year.
I'm bound to say I'm a bit surprised by this for two reasons. First of all, on any application for an interim injunction, one of the things the court needs to know is how long the injunction is likely to last, because that plainly is relevant to the exercise of the court's evaluation of the balance of risk of injustice, because generally speaking, an injunction that lasts for a short time is liable to do less damage than one that lasts for a long time, other things being equal, obviously. So generally speaking, you don't go into court without having some idea of when the trial date is going to be. But leaving that aside, the other thing I find surprising is why are we here in the first place? I mean, why was this case not subject to a speedy trial? We could have had this case tried by now rather than having an appeal. What's the point?
Well, the point of applying for the injunction and persisting with it on the appeal is to stop this material being published as soon as possible. And that was explicit in the application for permission to appeal, which was granted. I'm sorry, I can't assist you on the trial date. I'll try and take instructions on that. But the fact is, trials do take time. There's always the impediment of the case management and cost budgeting hearing to be dispensed with. And it was just felt on behalf of the claimants that they wanted to press ahead as soon as possible in order to obtain this interim injunction.
That's right, but there's a balance to be struck between having a long or indefinitely long interim situation and a known final solution to something of this sort. And I mean, this argument is taking place in the context of an interim which appears to be completely indefinite.
Well, my lord, all we can do is abide by the way the court lists these matters and do our best.
I understand. Well, could you, as we're talking about it now, so we don't forget about it, if you want to take any instructions about when, would you like to do that now?
Yeah. My junior points out, we're in the hands of the court because one can't list a trial until the CCMC takes place. And of course, at that hearing, then the court, it will hope, do its best it can.
So when is the CCMC to take place?
It's not been listed yet.
I'm puzzled by this, to put it mildly. First of all, the idea that proceedings are exclusively under the control of the court seems to me to be very strange. You can apply for a speedy trial. Obviously you didn't, but I'm mystified as to why not. But in any event, you make inquiries with the court as to when the likely trial date is. I mean, this is elementary. When you apply for an interim injunction, part of the preparation exercise is to find out from the trial when a trial date is likely to be available. And then you can tell the judge who's making the decision as to an interim injunction when that date is likely to be, obviously, until things have gone further, you don't know for certain. And that can be taken into account. It seems none of this has been done.
That's on my feet, that's correct, my lord.
Yeah. All right.
Can I make clear, this obviously doesn't bear at all upon the point of principle that we
Yes,
are considering. It's just putting into context what it is that we're here for today.
yes, and I do appreciate the court is always careful to use court time carefully. But can I just reiterate the simple point? We don't have a trial date. We hope it's as soon as possible.
Well, you don't at the moment have a date to get a date.
No, precisely. Budgets haven't been exchanged. These things take time, I'm afraid.
Thank you. Right.
Just looking up the court website at the moment, the website is showing that for a trial of up to 5 days, you would be looking at 29th January 2024 to 27th of March 2024. Yes. So if you wanted a speedy trial, you'd have to make an application. Obviously, I don't know what the position would have been if you'd made an application a couple of months ago. But anyway, as of today, that's what...
I'm grateful for that clarification. All I can say is the order sought. The order as it exists in regard to the house and the boat is until trial and further order. But of course, the defendant can always apply in the meantime to lift the injunction, to lift that injunction, or to lift any further injunction imposed by the court if circumstances change. My Lord, if you don't mind, if I proceed with the facts, the substance of the application, the appeal. The claimants have very strong links with Barbados. You'll see from the second witness statement, the second claimant, the husband's originally from Barbados. And they've maintained links with Barbados, and particularly they've kept their family connections and kept the heritage of their children alive by going there on holiday frequently. So the house they have in Barbados is more than just a holiday boat hole. It's very much a home for them. Now, they arrived there for a holiday with a group of friends and their 3 children on the 27th of December of last year. Now, they arrived on the evening of 26th of December. And as you'll see from the judgment and the second witness statement of the second claimant, they were targeted immediately on that day. One of the daughters noticed 2 female paparazzi, I'm going to call them, photographing them covertly as they walked past the daughter and her parents on sunbeds. Then transpired these 2 women went to another side of the beach.
Yes, we know all this.
Yes, yes. Thank you very much. So we say that that's targeting of a high order, and it amounts to harassment, if you wanted to use that word. And of course, it's relevant that the claimant's being spied on. You've seen the photograph of the house. It's not necessarily clear from the printed version, but from the web version, the electronic version, you could see 3 individuals there. And the second claimant believes it's 2 daughters and another boy. Now, turning to the 28th of December, of course, there's a trip, the family trip, to a restaurant to celebrate the birthday of the 18th-year-old daughter, which took place on that day. Now, a leitmotif that's going to be running through my submissions is not only was this as a whole a family activity, because it was a family holiday, but going to the restaurant itself was a family activity. And for reasons I'll come to, the authorities all give strong protection to the photographing, or to prevent the photographing of family activities. Now, many photographs were taken. None of the subjects knew they were being photographed at the time. The second claimant's clear evidence is that she arrived at the beach, the whole group arrived at the beach 100 metres away from the restaurant. And where they arrived at the beach was deserted. The people who were around were 100 metres away at the restaurant when there were 30 or so people outside the restaurant on the beach, and a considerably greater number in the restaurant itself. Now, there were 2 Sun on Sunday articles published about this. The photographs you'll have seen show Mrs. Stoute and Mr. Stoute in what we would call beach attire. Neither photograph makes anything of the fact that the claimants arrived at the beach by jet ski, by a single jet ski. Whilst each article mentions that they arrived by jet ski, nothing is said about that. It's no great focus of the story. Now, it's part of Mr. Justice Johnson's reasoning and the argument submitted on behalf of the Group Newspapers that it somehow is remarkable and somehow diminishes the reasonable expectation of privacy. And we say that can't be so, because it's just a question of getting from A to B. And there's nothing to rebut the evidence given by the second claimant in that regard. We'd ask you to disregard references in the defendant's skeleton argument to the speed at which the jet ski arrived at the beach, because there's no evidence of that. The only evidence is that of Mrs. Stoute. So she arrived at the beach, photographs are taken, they don't know what's happening. Now, on that evidence, as accepted by the judge, the only people who can see them is 100 metres away. That's nearly the length of a football pitch, so they're not going to see very much. And just before I leave the evidence, the second claimant, of course, gives evidence about the upset caused to them by the harassment on the 27th of December, which of course was visible. And you'll see she gives evidence there of the sense of unease amongst the family, amongst the wider group, as a result of that. And she also gives evidence as to the effect of the publication upon the group. And including, she also gives very pertinent evidence about when we're talking about continuing publication, why this needs to be nipped in the bud. The authorities indicate that each fresh look at those photographs will be a fresh misuse of private information, a fresh intrusion. And we say Mrs. Stoute gives powerful evidence to the effect that she is a businesswoman. As she says in a witness statement, she's not a swimwear model. She doesn't deserve to be photographed in this way, and those photographs published to hundreds of thousands of people on the website and in the print editions of the Sun on Sunday, and currently ad infinitum on the website. So there's a very real fear there will be further intrusions. Now, if I can then proceed very briefly to identify the 4 key issues of law before the courts in summary form. The first question, of course, is there a reasonable expectation of privacy? And that is a multifactorial consideration which requires the court to look at all the circumstances of the case. The second question is, if the claimants succeed in establishing there's a reasonable expectation of privacy, is there a countervailing Article 10 right, which, if I can put it this way, outweighs the Article 8 right? The authorities are clear on this, that the type of speech in issue here, and the authorities also hold that the fact this information is portrayed in photographs is important. These types of photographs add nothing to a debate of general interest. They're at the very bottom of the pecking order of what is protected by Article 10.
In any case, this argument is not being run.
No public interest defence at all.
No.
And
I quite understand that you wish to make sure that is not lost to sight.
Yes.
But actually, it's not being run, so the press can have no benefit from it.
Yes. Then the third question is...
Similarly, they can't not run it and then seek to bring it in by the side door.
No, even...
When considering what is and what isn't private.
Yes. Yes.
We're alive to that.
I'm grateful for that clarification. Then, of course, further Section 12.3 of the Human Rights Act, the court very broadly has to look at whether the claimants are likely to succeed at trial or not. We say that if we're successful on overturning the decision on reasonable expectation of privacy, that case advanced by the claimants is irrefutably strong, and they would satisfy Section 12.3 on the facts before the court at the moment. The last question really is a final wrap-up consideration of whether the court should apply its discretion, given that there has been publication of the photographs already. And we will say, relying on the authority of PJS, that where there's something still worthwhile protecting, that in those circumstances, further intrusions ought to be prevented, regardless of the scale or the fact of...
Your argument, as I understand it, is that if you succeed in showing that the judge was wrong in relation to the first point, then everything else follows.
Yes.
I appreciate that. May not become grand, but
that's your
submission.
It's the broad submission. My lords, if I could go through the case law. Now, firstly, we said this...
Before we embark upon this,
yes.
is it suggested that there's anything tricky about the case law, or that there isn't a clear position in regard to these matters? Are you about to take us down a straight road or a twisty one?
It's a straight road. It's going to be geared to showing where Mr. Justice Johnson went wrong. Okay. And it's going to be geared to showing, in particular, rebutting the argument put forward by the respondent that somehow the Von Hanover case isn't applicable in the English court, and that somehow Campbell is different from it or applies different principles, and we say that's wrong.
Could I interrupt my own question, just before we leave the facts? Was it your submission that the manner of arrival at the public beach is something that the judge should have put out of his mind?
He can look at all the circumstances.
Right, that's not the submission. What you told us was obviously the speed of arrival. There was no evidence about it.
No.
So that is not something that the judge knew. But the manner of arrival, which is something that he was clearly struck by, was your submission that he had to ignore that, or that it was just one of a number of features?
He can take it into account, but there's a sentence in the judgment where he describes it as performative and demonstrative.
What's wrong with that?
That's his evaluation. We say...
exactly. So why was he not entitled to say that?
Well, he was entitled... He was certainly entitled to say it. We say it's plainly wrong, because the only evidence he had was that a group of people went from A to B from a boat to a shore side. And if he is going to bear that in mind, it's not a major factor. It certainly can't be a factor where, to take it to the extreme, the claimants would have had a reasonable expectation of privacy. For instance,
so when you come to make your submission about that, it will be that he attached too much weight to that.
Yes.
Thank you. Okay.
Yes.
To be clear. All right. So on to the law.
Now, Campbell is the wellspring from which the tort of misuse of private information arises. And I'm just going to go through some of the general principles that were arrived at in that case. I can start, the minority judgments were given by Lord Nichols and Lord Hoffman. But in fact, the minority judgments only really disagreed with the analysis of the particular facts of the case. The broad principles, the 5 law laws, were broadly in agreement. And I'm just going to start off by relying on a statement by Lord Hoffman at paragraph 51 on page 19 of the authorities bundle. That's paragraph 51.
Yes.
Just reading down from paragraph C. At this stage, the court is trying to evolve the misuse of private information tort out of the action for breach of confidence. And you'll see just under paragraph C, he says, instead of the cause of action being based upon the duty of good faith applicable to confidential personal information and trade secrets alike, he focuses on the protection of human autonomy and dignity, the right to control the dissemination of information about one's private life, and the right to the esteem and respect of other people. So we can see that it's a fairly broad tort, which we would demonstrate extends beyond merely considering the information itself, which is displayed in a photograph or otherwise. If I then ask you to turn to paragraph 122, which is at page 37 of the authorities bundle. Now, just to make clear, it starts there at paragraph 122. The photographs were taken of Miss Campbell while she was in a public place. She was in the street outside the premises where she had been receiving therapy. The taking of photographs in a public street must, as Mr. Justice Rance...
Do you want us to read some of this to ourselves? So how much?
If you could read from paragraph 122 to paragraph H, indent H on page 38, please.
Yes. Yes, thank you.
Yes, so paragraph 122 makes a distinction between, for instance, arriving on a beach and other people seeing you on that beach. There's no problem with that. There's no problem with another beachgoer incidentally photographing the claimants as part of their holiday. And the claimants or the appellants in this claim don't claim they had a reasonable expectation when they arrived at the beach that no one would see them or that they wouldn't be in the background of other holiday snaps published by other people. But the key distinction made clear by Lord Hope here is that what the misuse of private information tool is concerned with is the dissemination to other people and the scale of publication. And this picks up on a point which I'll come to later when Lord Justice Warby gave permission to appeal, where he referred to the fact there may be different reasonable expectations of privacy. There's no reasonable expectation of privacy when you're standing on the beach that someone in the restaurant, for instance, would see you. But that doesn't mean there's no reasonable expectation of privacy in regard to those photographs being taken as a regard further to targeting by paparazzi and then being published by hundreds of thousands of people in a newspaper. We say it's obvious. There would be a reasonable expectation when one is on holiday, dressed for the beach, that someone isn't targeting you and taking photographs of you in that incident for publication to the world at large. Now,
Is there a halfway house? If, say, somebody else who happens to be on the beach spots a famous person and thinks, "Oh, I'll take a photograph of them," and then might later think, perhaps I could make some money out of this by selling it to a newspaper.
It's all depending on the facts, but there must be a good chance that the court would accept there's a reasonable expectation of privacy in that case, because that person, the photographer, is the beachgoer suddenly is acting as a photographer, taking a photograph for money and targeting someone because of their fame. And again, the key will be disseminating it to hundreds of thousands of people. Of course, it's possible that a beach snap of Brighton Beach on a Monday, bank holiday Monday, where you see hundreds of people stretched out in the sun, is going to be published to many people at large. But you won't have targeting. And that's the key distinction. Targeting and the scale of publication. Now, paragraph, we're going to...
So it comes down to that there's no reasonable expectation of privacy from other diners in the restaurant or other users of the beach. But there's a reasonable expectation of privacy, you say, in relation to people in South London and Merseyside and Hull. Yes.
And for those photographs to be published indefinitely on the website. My lords, one point that the respondent will rely on is what I'm going to come to shortly, the bottle of milk example given by Baroness Hale. We say that's a counterfactual given by her. But there's also a counterfactual given here by Lord Hope, just by paragraph E, paragraph 123, sidelining paragraph E. Miss Campbell could not have complained if the photograph had been taken to show the scene in the street by a passerby and later published simply as a street scene. That's the counterfactual he advances. The court wasn't trying to deal with other scenarios, but both he and Baroness Hale clearly made some attempt to define the limits of the talk, but then clearly he says that's different from photos taken deliberately in secret with a view to publication with the use of a zoom lens. Now, just turning to now Baroness Hale's judgment, which you'll find the relevant paragraph is paragraph 154 at page 47 of the hearing bundle. Now here, Baroness Hale gives a counterfactual. She's clearly made her decision about the fact that Naomi Campbell did have a reasonable expectation of privacy in these circumstances. She says at the beginning there, taking the photographs is in itself unexceptional. She says the mere fact of covert photography is unexceptional. So I've made the error of not asking you to read paragraph 154 first.
Thank you.
If I could ask you to read that first, yes, and then I'll make my submissions. Now, the principles of law here will have to be applied in multiple situations, but the counterfactual posited there by Baroness Hale has nothing to do with the facts of this case, because the popping out for a pint of milk is not, on Baroness Hale's analysis, a private activity, whereas the activity on the facts of this case is a private activity by the fact it's a family holiday and it's a family outing to celebrate a family member's birthday.
I don't quite get that distinction. I mean, Article 8 covers family life and private life. And Baroness Hale appears to be accepting that popping out for a bottle of milk is part of your private life, even if not a very...
I'd say she's not accepting that that's part of your private life, as it would be protected by Article 8.
Well, there's nothing essentially private about that information, nor can it be expected to damage her private life.
Yes.
It's part of her private life. It's not saying it isn't part of her private life.
Yes, but it's not something the law will interfere with. I'm dealing with this point because much is made of it by the respondents.
Well, you're making a point about the family aspect of the event.
Yes,
that's right. But it wouldn't. I mean, your case wouldn't necessarily fall to the ground if you just happened to have gone on your own to the restaurant.
No, it's one thing that one needs to bear in mind. There are a multitude of factual situations here. The court still just has
I'm only querying the distinction that you're seeking to introduce between private life and family life. Both of them are protected by Article 8.
Oh, pardon me. I'm not seeking to draw a distinction. I'm saying it's what distinguishes the facts of the case before this court from the facts of the counterfactual put forward by Baroness Hale there.
But I'm not. I'm just interrogating that because, I mean, this may be going to the restaurant for a family birthday party. May not be popping out for a pint of milk, but it's popping out for something. I mean, I'm not quite sure what the difference is. In conceptual terms, locally it may lead to a different outcome in the overall analysis.
Because Article 8 explicitly protects family life, and the Court of Appeal cases of Murray and Weller, which I'll come to shortly, explicitly say this is something that should be protected. And in both of those cases, it was just a family trip, in one case to a cafe, one case to go shopping. Just before I leave Baroness Hale's example there, of course, the other distinction is Baroness Hale makes much of the fact that Miss Campbell wouldn't have cause to complain here because she makes her living out of being photographed, whereas, of course, the claimants in this case don't do so. And also, you've got the fact, the claimants' evidence, that they find their future behaviour will be impinged by this activity. It makes them fearful of going out. It makes them worried about what might happen in the future.
Why is it relevant that it's a birthday? I mean, either going to the restaurant and being photographed on the beach infringes a reasonable expectation of privacy, or it doesn't, I would have thought. The fact that it happens to be one member of the party's birthday seems neither here nor there, really. Ooh. If they'd gone on the next day instead, would that be a weaker case for you?
Not necessarily. It's the fact it's a birthday party. The case doesn't stand or fall on that. But we say that does demonstrate it was already a family outing, with or without the fact they were going to celebrate a birthday. But the fact they were going to celebrate a birthday reinforces the fact that this was a family activity. Just before I leave this page, the very last sentence of paragraph 155, where Baroness Hale is talking about the actual harm caused to Miss Campbell. Baroness Hale says in that last sentence, in context, it also added to the potential harm by making her think she was being followed or betrayed and deterring her from going back to the same place again. And we pray the same principle in support of the claimant's case on the facts before you. Now, Douglas is the next case. Douglas establishes two principles of importance for the court's consideration today. That's the importance of photographs and why photographs should be looked at differently from the printed word. And it also deals with why a public domain argument will be less strong in regard to a photograph. Now, I've quoted the relevant extracts extensively in the claimant's skeleton argument. There's no dispute on the law in that regard. So I'm proposing not to go through the case of Douglas, given that those two propositions are uncontroversial.
Just repeat the second one, please. The second one was?
Oh, the second one was when one's looking at if there's been prior publication and the respondent says, well, look, you can't have an
Prior
injunction.
publication is not the end of it.
No, particularly because they're photographs. Whereas in PJS, the House of Lords case, which is leading authority on this, concerned only words. But even in PJS, the Supreme Court found that what you need to do is look to the future harm, not the previous harm. McKennett-Nash, which is at tab 3, is a case relied upon by the defendant. We say it's neither here nor there. It's a first instance decision concerning a book published by the former personal assistant, Miss Kennett, which revealed private information. It's not a photograph case, so we say it doesn't exist.
Surely we should have regard to the Court of Appeal decision.
Oh, yes,
rather than the first instance.
Yes, and I'm going to deal with some of the passages in the Court of Appeal decision. I'm really getting my retaliation in first against my opponent by pointing out why this case is irrelevant. Similarly, the case of Elton John at tab 4 is irrelevant. It's just an instance where a photographer happened to be on a pavement, which perhaps goes back to the earlier example given by the court. A photographer's on the pavement. He noticed Elton John walking from his car across the pavement to his front gate, and the photographer fortuitously, as Mr. Justice Eadie found, took a photograph and published that information of Mr. John on a pavement. Again, we say it's neither here nor there. It doesn't establish any principles and is not comparable with what's in issue before this court, not least because, and I refer to my leitmotif again, of the fact that this concerned a family activity. Now, McKennett-Nash Court of Appeal decision is at tab 5, which of course will be more of interest to this court. And at page 188 of the bundle, so the authorities at tab 5, page 188 of the bundle, indent paragraph G, you'll see there the two-stage test, which is in fact quoted at paragraph 21 of the claimant's skeleton argument. And then proceeding, I'm going to refer briefly to paragraphs 37 to 42. That begins on page 196. Now, this is a detailed analysis of why the von Hanover case is not in conflict with Campbell and why von Hanover represents good law and should be followed by the courts in this jurisdiction. I'm not going to go through those paragraphs, but if I can just highlight them for future reference. So paragraphs 37 to 42, and just summarising paragraph 42 there, where the Court of Appeal said, I would therefore conclude that to the extent it's the first defendant's case, the judge should not have regard to von Hanover when considering the first question of whether Article 8 was engaged. To the extent that, if at all, that issue matters for the determination of this part of the case, the complaint is unfounded. And the same point is made by the Court of Appeal in the case of Murray, which I'm now going to proceed to. Now, in this case, the mother of the child was the well-known author J.K. Rowling. She was out with her husband and with a security guard with a 19-month-old child in a pram. And they were photographed by paparazzi, and they sought an injunction to prevent those photographs being published. I should say the claim was only brought in regard to the 19-month-old child. It wasn't brought in regard to any of the adults. But we say that's neither here nor there because the principles to be applied by the court are the same. If I can ask you to turn to page 226 of the authorities bundle. And really, it's paragraphs 17 and 18. If I could just ask you to read 17 and 18 down to 3 lines from the bottom of the page, please.
Thank you. Right, so not an isolated event.
No, it's similar to one Hanover. You can see there's been, I could call it stalking, and whilst of course this court's not bound by the facts in other cases, and sometimes it's dangerous to look at the facts of other cases, if one does look at the facts of the claimant's case, then it's on all fours with this when one looks at what happened on the 27th of December and then the 28th of December. And the misuse of private information taught in establishing whether there's a reasonable expectation of privacy, that type of activity will be relevant.
You say it's on all fours.
Well,
and you may be right. But at some point we're going to grapple with the fact, are we, that in the knowledge that they were being pursued by photographers, the arrival on the 28th was by sea in the way that it was.
yes, certainly
Public
that's...
beach. I mean, what we've got here is somebody just walking down the street with a stroller in the normal way. They're not on all fours.
Yes. I mean, what we would say, what's normal for the street in Edinburgh might be quite normal for a beach in Barbados, when one's just travelling from one area of the
yes, but you
seaward side of the
probably
island
accept
to
that
another.
the case might be different. Had they decided to travel by vehicle and just gone in the side door of the restaurant, there's no doubt some other front door of the restaurant, no doubt some other customers will have done.
The point made by the judge, which I'll deal with in more detail as I try and take that judgment apart, is we say to a degree that that's victim blaming. That's saying that the claimant should have altered their behaviour because of the impermissible, we say wrongful behaviour towards them, which took place on the 27th of December. It's, in applying privacy law, it's wrong to say that if someone's subject of this kind of activity, that the solution lies with them to alter their behaviour, to alter the way they conduct their private and family lives. Mrs. Stoute can't be expected to put it bluntly, walking around in disguise or things of this sort. They're entitled to move around in the way they normally do.
There must surely be, I mean, I appreciate I'm anticipating the argument, but it was you saying this is on all fours with Murray. But isn't part of the evaluation the judge has got to carry out, take into account, for example, the extent to which the claimants were protecting the privacy that they claimed?
Well, it's these claimants are not celebrities. They're not famous people. They're ordinary people who just so happened to establish what was already a successful business in 2003, supplying PPE to the National Health Service. Mrs. Stoute is a former nurse. Mr. Stoute, I don't know his career before the business was established in 2002. They don't make their business about publicising themselves to the world at large. They don't have their photographs in Hello magazine.
I think you're moving away from the point that I've...
Oh, pardon me.
These are no doubt all good points, but I'm focusing on the fact that they made a choice as to how they were going to go to the restaurant. And isn't that rather different from what we have here, which is somebody walking down the street?
We say no as a point of principle, that's not different. They cannot be expected to alter their behaviour because of the untoward behaviour of those individuals towards them on the 27th of December. They can't be expected for every day of their 2-week or so holiday to go around behaving in a way which is different from the way they'd be entitled to behave if they weren't being followed by paparazzi. And I would also say the photography which took place on the 28th of December was covert. The claimants could not see what was happening. None of the party of 19 people or so were ever aware they were being photographed. And we say that that's also relevant. If there are photograph prints where they saw the photographer and put their hands above their faces, then that would be obviously an indication that they didn't consent to being photographed. But in fact, they made it very clear on the 27th of December that they would not tolerate this behaviour. And there was an altercation on the beach, at the end of which those photographers must have been absolutely certain that it was a question of not just consenting, but positively objecting to that kind of behaviour. Just before I leave this point, you've got to accept these are people who are successful business people, and yet they'll suddenly be thrust into this situation where the Sun on Sunday decides that they're material for publication of articles. Now, of course, Sun on Sunday can write articles about how successful they were in supplying PPE in their capacity as business people. But what they can't do is suddenly start publishing photographs of this sort of them in their beachwear, going about their business on a family holiday. And the claimants should not be expected to spend their family holiday in a different way. Cannot be said to be their fault those photographs were taken and published on the 28th of December.
Can I ask you about another aspect of your submission?
Yes.
That this case is on all fours in this respect with JK.
When I say all fours, that's a slight
what I was going to ask
exaggeration,
you
but in
is,
terms of these surveillance.
Isn't targeting and surveillance really a question of degree? I mean, it's one thing to be photographed on a public beach or when you go to the shop to buy a bottle of milk. If it happens once or twice, it might be something else if every time you go out there are paparazzi waiting for you. We seem to be closer to the former category here, aren't we? There was covert photography for a day or two. The photographers then got their photograph, the story was published, and I don't think there's any evidence that your client either continued during the rest of the family holiday or continues subsequently to face paparazzi whenever she goes anywhere.
Well, my lord, first we have to be careful of looking at events as they existed in January, where Mr. Justice Johnson heard this application. There's no submission by either side to submit additional evidence. But surely the point of obtaining an interim injunction is to nip behaviour in the bud. One of the points made by Mr. Justice Johnson is that the behaviour towards Princess Caroline continued for a 4-year period between 1993 and 1997. Now,
to be sure, and we appreciate the importance of that as a point of principle, but just on the factual circumstances, the point my lord was putting to you was that in her second witness statement, Mrs. Stoute, this is the 13th of January, does give further information about what happened on the 28th.
yes.
But she does not say, and it continued after the 28th. She certainly says, and you can make this point, that she was obviously concerned about the implications for herself and her family of what had happened on those 2 dates. But there's no evidence, is there, that there was repeated targeting by paparazzi on subsequent dates between the 28th of December and the 13th of January. I think that's the point.
I think that's... I think there's reference to another man, another photographer in the witness statement. I'm just asking my Jr. to check that witness statement. What Mrs. Stoute does do is give evidence about the fear in which the claimants are placed after publication. Now, we were talking about them should they have changed their behaviour on the 28th of January. We say no. But one can see that after publication took place, that Mrs. Stoute does give evidence, both in her open witness statement and in her confidential schedule to it, that there was a degree of fear and their activities were changed. And we also make the point that, yes, there haven't been further photographs published. We don't know if any have been taken covertly, but the point is there's now a price on their heads. It's known in Barbados and perhaps elsewhere that if you see the Stoutes, if you chase the Stoutes and get a photograph, the Sun on Sunday or other tabloids such as the Mail on Sunday, the Daily Mail, will publish them. And therefore we say an injunction does serve the salutary purpose of removing the price on their heads and taking away that incentive.
Is there? I mean, then, as you say, they're not that famous. And the story is that these are people who've made a lot of money from selling PPE during COVID, and look at them enjoying the proceeds. And that story's been run, hasn't it? It's not going to feature repeatedly, or editors will find they're losing sales.
Well, my lord, you might say that, and with the greatest respect, that's informed guesswork. One would have said prior to these photographs being taken, what on earth's the point of following two successful business people to Barbados, spending resources on the 27th of December, spending 4 people staking them out for a day photographing them, and then following to a restaurant on the 28th of December. And I would point out there's an explicit finding in the judgment that Mr. Justice Johnson found that there was a real risk, such as to justify the granting of an injunction, all other things being equal, of republication of the photographs by the defendant, Group Newspapers.
Well, that's rather different from the taking of new
Yes, it's different. He's talking about those particular photographs, but those particular photographs can be used to illustrate other articles. And the fact is, this furore is going to run, not because of anything Mr. and Mrs. Stoute did, who have not been criticised at all. In fact, Mrs. Stoute, you'll see, assisted the relevant House of Parliament committee on this. There is a scandal concerning the activities of, for instance, Baroness Mohn and other, you might people describe as carpetbaggers, who jumped on the PPE bandwagon when the COVID pandemic broke out. The newspapers haven't been able to find stories about them. They're hidden. And the problem is that Mr. and Mrs. Stoute get caught up in that and become, through no fault of their own, there's no criticism of them, caught up in the story, such that newspapers want photographs of them. And it's not just the Sun on Sunday. The Daily Mail also published the same photographs. Just on the Princess Caroline point, being good law, if we just refer you to paragraph 234 of the bundle. You'll just see indented there Roman numerals 9. That's an extract from the first instance judge's judgment, where effectively he summarises what Van Hanover was about. I'll just ask you to read it briefly.
Yes.
And then turning forward, I'll come to it shortly, but the Court of Appeal approves that explicitly approves that summary of the law given by the first instance judge. And then if I just turn to paragraph 50 on page 238. Page 238, indent paragraph H. As Lord Hope put it in Campbell, to show the scene in a street by a passerby and later publish as street scenes, that would be one thing. But they were not taken as street scenes, but were taken deliberately in secret with a view to their subsequent publication. They were taken for the purpose of publication for profit, no doubt in the knowledge that the parents would have objected to them. And then over the page, at page 239, I rely on paragraphs 54 to the end of the second sentence of paragraph 56, if I could ask you to read those.
Yes.
Now, in regard to paragraph 54, you'll notice in the respondent's skeleton argument, what we say as a straw man is set up, where the respondent claims that we're arguing for an image right, and we're not arguing for anything of the sort. And it's quite clear there that we wouldn't succeed if we were. And then what emerges from that learning is that last sentence of paragraph 55. Well, pardon me, I just row back from that. It's really the top of page 240. We agree with the judge it's indeed the basis of the European Court's approach. We do not agree that it's possible to draw a clear distinction in principle between the two kinds of activity. That is, very roughly, going out to buy a pint of milk activity and family activity. Thus, an expedition to a cafe of the kind which occurred here seems to us to be at least arguably part of each member of the family's recreation time, intended to be enjoyed by them, and such that publicity of its intrusive nature, of its intrusive, such as adversely to affect such activities in the future. Again, the reference to the importance of future activities. And it says we don't share the judge's, the first instance judge's predisposition to find that routine activities wouldn't have attached to them a reasonable expectation of privacy. Now, just briefly, paragraph 59 on page 240. I'll just ask you to read to where it refers to paragraph 43, Roman numerals 9, which I've already referred the court to.
Yes.
And just so you know, the citation there, 2008, Queen's Bench 73, that's a reference to the McKennitt decision in the Court of Appeal. So in Murray, the Court of Appeal again is saying that there's no reason to distinguish von Hanover. It's good law. And if I just proceed to the case of Dreeser, which is at tab 7, we say again, this is neither here nor there. It's a case relied upon by News Group newspapers. The claimant was in person. The claimant was a prisoner who was photographed carrying out exercise whilst in prison. It doesn't establish any principle at all. The case of Weller, we do say is important. This is a case where Paul Weller, the famous musician, who himself, as I suppose one might say, in regard to J.K. Rowling, might expect to be photographed, but wouldn't expect his children to be photographed, who were photographed on the pavement in Los Angeles. There are 3 children, one 16-year-old and 2 very young twins who were 10 months old. It's tempting to look at this case in Murray and say, oh, but these cases are about children. But in fact, the court doesn't necessarily, the court clearly grants enhanced rights to children because of their particular attributes. But these principles are applicable generally in their protection of adults as well. Weller at paragraph 29, which is on page 258.
Well, hold on. Paragraph 56 of Murray, you asked us to read the first sentence, but the next couple of sentences say that the position of an adult may be very different from that of a child.
Yes.
So they draw precisely the distinction which you say they don't draw.
Yes, it may be very different, and the court's likely to give more protection to a child. But the tort still protects any adult who fits themselves within these general statements of principle, such that they have a reasonable expectation of privacy. And I did take you to a part of that judgment where the court considered that each member of the family had a reasonable expectation of privacy. There's not a clear line to be drawn between adults and children, and both Murray and Weller, in the general principles expressed in them, are applicable to adults. It's at Weller at paragraph 29 on page 258 deals with this in paragraphs 29 and 30. I'd ask the court just to read those 2 paragraphs. So really that deals with the interaction or the intersection between the rights of children and adults. There's no bright dividing line. Reasonable expectation principles are the same in both cases, and children don't have a separate privacy right. And of course it's relevant when in the case of Murray and the 2 10-month-old children in Weller, that in fact no distress is going to be caused to them, but they still have a privacy right. So that shows the degree to which a privacy right might be enforced when a child or even an adult, we would say, is engaged in a family outing. Now, at the top of page 259, the court then referred to the factors listed at paragraph 36 of Murray, which I hope I took the court to. Paragraphs 35 and 36 of Murray are crucial. In paragraph 36, the Court of Appeal set out what we would call the Murray factors, what the court has to bear in mind when analysing whether there's a reasonable expectation of privacy or not. And for reasons I'll flesh out in greater detail shortly, Mr. Justice Johnson didn't apply the Murray factors when analysing whether there was a reasonable expectation of privacy on the facts of this case. Forgive me, confessing as an advocate, I think I took you to paragraphs 35 and 36 of Murray. If I didn't, they are crucial pieces of
They
Murray.
were referred to in the skeleton.
Yeah.
Yes.
I don't think you did just now.
Yes.
I'm sure you all got them on board because
Yes.
they were referred to in the skeleton.
I'm grateful for that. So the Murray factors are located at paragraph 36, and you can see at page 259 of Weller, the Court of Appeal then considered to go through them. And then page 266 of the authorities bundle. If I could ask you to read paragraph 61, down to paragraph 63 down to the word reklos, as in reklos in Greece, just below indent D.
I'm sorry, I missed that. Which
Or pardon me,
paragraph do you want
page
to read?
266 of the authorities bundle.
First half of the page.
From the top of the page down to paragraph 63, down to that part of 63 which begins with the word
I'm
reklos.
there now. Thank you very
Thank
much.
you. So paragraph 61, you can see at the end an emphasis on the fact it's a private family outing. And in the last sentence or so, that, in the view of the Court of Appeal, was a crucial distinguishing factor from the example given by Baroness Hale of popping out for the pint of milk. Then, for completeness, just make sure you don't think I'm missing it, you see at paragraph 63, it says the critical factor which mitigates in favour of the claimants, and this is claimants who are children, is that they are children they've identified by the surname. The twins were less than 1 year old. They did not knowingly or accidentally lay themselves open to the possibility of having their photographs taken. So you can see there will be an enhanced right for children, but it's still fundamentally the same right to which the same principles apply. And we would just say in the case of the Stoutes, they're not people who've made themselves into celebrities or anything of that sort. They're not like the J.K. Rowlings or the Paul Wellers of this world, who might expect to be photographed. They are private business people. PJS...
I'm sorry, you keep making this point, but they're not just private business people. They're astonishingly successful.
Yes. Yes, and the text of the first Sun on Sunday article deals with that. And there's no complaint about the text. The Sun, it's a legitimate news story.
Yes, I know, but the fact that they're astonishingly successful business people in a particular context rather distinguishes them from what you've been describing to us as just being the ordinary man and the woman in the street.
Well, they are. The successful business person, however successful, doesn't thereby open up their private life.
No, I understand that, but
Public
it's
scrutiny.
a feature.
That's-
It's one of their attributes, is that they're extraordinarily successful.
Yes, I clearly I can't gainsay that.
And that they're extraordinarily successful in the context of winning public contracts.
Yes.
Right. Now, what about the last sentence of paragraph 63 that you took us to, which is the rec loss point? What was Reclos about?
I haven't read that case.
Right.
I think the point is a child up to 16, for instance, will just have to do what a parent tells them to do. So when a child goes to a beach...
Yes, but I understand that. I understand the point about the child. But what was Mr. or Mrs. Reclos up to that led to the comment of knowingly or accidentally laying themselves open to the possibility of having their photograph taken in the context of an activity that was likely to be recorded in a public manner?
All I can say is I'll take steps to find out over the lunch break and ask my junior to see if she can find out now.
This may or may not be relevant to the questions I've been asking you before about the method.
It's not
of writing.
relied on by the respondent.
Once you accept, as you did, that this was a legitimate news story about people who have made a lot of money from dealings with the NHS during the pandemic, isn't the photograph part of the context of that legitimate story, in that it shows the claimants enjoying the wealth that they have earned?
No, because it's a step too far. Sorry to repeat my point, but if one's a successful business person, one's not in show business or anything like that, clearly that success is through obtaining government contracts. Clearly an article can be written about that success. An article can be written, and in fact was written, about the amount of money involved. But that doesn't, we say, open the door to people like this being followed on holiday in the manner in issue, having photographs taken in these circumstances, of having those photographs published to the world at large. As Mrs. Stoute says in her witness statement, she's a businesswoman, she's not a swimsuit model. Those photographs of a woman on a beach wearing what she was wearing, of a man on a beach wearing what he was wearing, tell you absolutely nothing and contribute nothing to a story about their success as business people.
Right.
And as long as there's a reasonable expectation of privacy, we would say for the ordinary man in the street in regard to photos like that, there's no reason why the claimant should be treated any differently. Of course, if they were photographed in the street attending Parliament to give evidence to a select committee, or the photographs of them going about their business. In the original article, there's a photograph of Mrs. Stoute holding a clipboard, wearing a high-vis vest. Then clearly that's all, in terms of privacy, that's fair enough because it's pertinent to the story. This material about what people did on the beach in Barbados is neither here nor there, and contributes to no debate of general interest. PJS, which is the legal authority on really the public domain argument as to whether an injunction should be granted or continued if material has come into the public domain. It's not a case about photographs. It's a case where an individual wanted to recount his sexual relationship with the claimant. Ultimately, an injunction was granted by the Court of Appeal, overturning an earlier decision. But then the material, the written words, were published widely outside the jurisdiction via the internet. There's then a further application to the Court of Appeal by the newspaper concerned, Group Newspapers, that the injunction be discharged because of the wider publication. Court of Appeal found that the injunction ought to be discharged. But when the Supreme Court reviewed that decision, it found that the injunction should be maintained. And what the Supreme Court did, in essence, was hold that the one looks at future harm. There may well be historical harm, but one looks at future harm. Is it a worthwhile exercise to prevent such harm occurring in the future by maintaining an injunction, even though there's been publication elsewhere? And the Supreme Court's conclusion on that was that emphatically that is the case. Now, just briefly to go through this, at paragraph 3, at page 278, reference to King Canute features in this judgment, in fact, features in the skeleton argument of News Group. You'll see there that Lord Mance, who gave the decision of the court, says it's all very well talking about King Canute, but the court does have power to limit further publication. And as he goes on to explain, in those circumstances, it ought to exercise it. Turning to page 278, pardon me, not 278. Page 287. Just ask the court to read paragraph 23 there, the indented paragraph 100, just below sideline number E.
That seems to be all about justification.
Yes, what it does talk about is it's not right that because someone's a public figure, that therefore it's open season on their private lives, which really goes to the point made by the court.
I think we got that point.
I was grateful for that. Page 288, paragraph 26. Second sentence. So even if quantitatively there's been extensive previous publication, an injunction may still be worthwhile to prevent further internet exposure, which will add significantly to the overall intrusiveness and distress involved. Now, paragraph 29 of the judgment, page 290 of the authorities, quotes approvingly a first instance decision of Mr. Justice Eadie in the case of CTB, and we rely on the indented paragraph 24 of Mr. Justice Eadie's judgment. Now, I won't go to it. Paragraph 41 is mentioned in our skeleton argument, and that deals with how important an injunction is because damages are really not a good enough remedy when it comes to a misuse of private information case. Now, the case that's been much heralded is the case of von Hanover which you'll find at tab 10 of the authorities. For reasons I hope are clear, there's nothing in the decisions, it's explicit in the decisions of McKennitt and either Murray or Weller, that this is good law and applicable, and is not in conflict with any English authority. At page 50, paragraph 59, page 332, so that talks about the photographs, and it's clearly a factor on this case, but it's just one factor. The last sentence there, paragraph 59. Furthermore, photographs appearing in the tabloid press are often taken in a climate of continual harassment that induces in the persons concerned a very strong sense of intrusion into their private life, or even of persecution. And we say that the second claimant, Mrs. Stoute, speaks eloquently to that effect upon her family in her second witness statement. Paragraph 63, just briefly, page 333, points out that Princess Caroline, despite her title, exercises no official, governmental or similar functions. Therefore, there's no reason to publish photographs of her going about her private business. Paragraph 68, similarly on page 334. Also indicates that it is a factor in analysing a misuse of private information case to how the photographs were taken. And again, we say the claimant's case on that is very strong indeed. And just lastly, paragraph 77 on page 335. And just mentions what might have been obvious from the English authorities anyway. The right of privacy doesn't depend upon whether the place where the activity being photographed is secluded or not. Now, the next authority is that of Lilo Steilenberg, again, European Court of Human Rights. This is relied upon by the respondents, not the appellant. The important point is it sets out no principle of law. It's originally a Norwegian claim brought by a well-known musician and a well-known actor who complained that their wedding, photographs of them arriving at their wedding, I believe, had been taken and published in the media. The Norwegian Supreme Court overturned the injunction, and the European Court of Human Rights upheld the decision of the Supreme Court. The important point to note in the European Court of Human Rights reasoning is very emphatic that it's applying a margin of appreciation to the decision-making exercise that the Supreme Court of Norway undertook and to the laws of Norway, which, as long as they were broadly congruent or in accordance with Article 8 and 10, wouldn't be interfered with. And just briefly on the facts, if you look at page 348 of that judgment, indented there is the decision of the Supreme Court of Norway. In paragraph 50, just about 5 lines from the bottom, you'll see it says, however, a certain amount of weight must be given to the fact the wedding was organised in a very unusual way. And then indented paragraph 51, 4 lines from the bottom, the arrangements were also spectacular in themselves. Paragraphs 43 and 45.
See the arrival of the bride in an open boat was a fact.
Yes, with the choir singing. Yes. And paragraph 33 on page 355. This is really the European Court of Human Rights giving a margin of appreciation to the Supreme Court. It's really paragraph 33, just indented paragraph 85, which is from the case of Axel Springer, and indented paragraph 88 over the page. Just to elaborate on those rather unusual facts, they're spelled out in paragraph 43, page 358, where there's a reference to the wedding being organised in a very unusual way. For example, with the arrival of the bride in an open boat, and the presence of a men's choir singing a hymn on the islet. And in that case, it was deemed to be relevant that the two celebrities, the musician and the actor, were well known to the public in those roles, which of course are very public-facing roles. That's how a musician and an actor make their income, as it were, by performing to the public. I won't take you to Axel Springer because, in effect, I've just relied on a quotation there set out in the Lilo case. There are extracts from Gatley on libel and slander in the bundle. We say in the light of the authorities set out what the law is. Gatley on libel and slander doesn't add to it. We've also included passages from the book Media, Law of Privacy and the Media. There are 3 paragraphs set out in the authorities bundle, which were referred to by Lord Justice Warby when he gave permission to appeal. And essentially, as he pointed out in giving permission to appeal, what those passages he referred to, which you'll find at page 245, page 407 of the authorities bundle, paragraph 5.105, then over the page at 5.139 and 5.141. And really that's the point we make, that it's quite possible to have, as a matter of fact, there was no reasonable expectation of privacy to other people who might have been on the deserted beach or who might have been 100 metres away at the restaurant. Just because there's no reasonable expectation of privacy in that doesn't mean there isn't a reasonable expectation of privacy in regard to the publication of photographs taken on those occasions, the dissemination to hundreds of thousands of people and ad infinitum on a website. My lords, with that I move along to the crux of the appeal, and that is our argument that Mr. Justice Johnson erred in law and or was plainly wrong in the conclusions reached by him, which culminated in him refusing to grant an interim injunction in the claimant's favour. You'll find the judgment at tab 6, page 56 of the core bundle. We've set out in detail in the skeleton argument the criticisms made of this judgment, but if I could set out two mistakes in law made by Mr. Justice Johnson. The first one, which I've alluded to already, is that he wrongly concluded that because there was no reasonable expectation of privacy in regard to other people on the beach, there was no reasonable expectation of at all.
So that's
Therefore,
the Tugendhat 5105 point.
Yes.
Right.
Yes. And the second one is the presumption, the wrongful presumption made by Mr. Justice Johnson that an event that takes place in a public place is not private, is not protected by this tort, unless there is an additional factor, such as one of those listed by him in paragraph 33 of his judgment. The mischief there, we say, is that he failed to follow paragraphs 35 and 36 of the Court of Appeal's judgment in Murray, where what I've referred to, the Murray factors, are set out, what the court needs to consider in deciding.
That's very helpful to have the two mistakes in law identified. Would you mind, just in order we can make a point in our note where we have everything in one place, what are your further complaints?
Everything else is that the decision-making process ended with a decision that was plainly wrong.
Right. So the balancing of the factors,
yes,
one way, led to a decision not open to the judge.
Yes.
Plainly wrong. Is it part of that submission that he either introduced some impermissible factor or that he omitted some obviously relevant factor? Would
you mind if I make my submissions with reference to the judgment itself?
I'd rather have it in clear sight where we're going.
Very well.
It doesn't. The judge doesn't have to get things wrong in every single way.
Yes.
I'm just anxious to know which ways you say this judge went wrong. I mean, you trailed an argument, for example, that you didn't use the Murray factors.
Yes.
Does that mean that we're going to be told in a minute that there's something that's of obvious relevance here which he simply didn't take into account?
Yes. The fact
or is it that in making the balance he didn't take it into sufficient account?
Yes. It's one thing he didn't bear in mind at all.
Right.
Was first of all publication to the world at large, which is in effect dealt with in the first question of law I raised. But also he didn't consider at all the fact that this was a family activity.
So that's the additional point. But
yes.
Well,
and sorry, just one more. He didn't consider the effect on the claimants. That is the effect upon a person of ordinary sensibilities.
Right. So
based in
we there have a bird's eye view of what you're about to now go on and make good. All right. Thank you.
Now, if I can start with page 60 of the core bundle. This is subparagraph 8 in the brackets, 2/3 of the way down.
Well, is there a complaint about the self-direction at paragraph 17 as a whole?
No, I'm only going to pick out 2 points for complaint.
So, no complaint apart from, the first is?
It will be paragraph 17, subparagraph 8. Now, what the judge does there is he only considers the reasonable expectation about being photographed and doesn't take any account at all of the imperative consideration to take account of the fact the photographs were published and the scale and nature of those publications. And we complain about subparagraph 9, which is fleshed out in paragraph 33 of the judgment, where the judge says a claimant may enjoy a residual privacy in respect of some events, even if they take place in public, because there's a zone of interaction of a person with others, even in a public context. Now, whilst looking at that in isolation, you may think there's not much wrong with it, but when one comes to how that's elucidated upon by the judge, one can see how it went wrong. Because a claimant in a public place, the starting point is just to look at, and clearly quoted Lord Justice Arnold's guidance in the case of Ali and Aslan. The point is to look at all the factors in an open-textured, open-minded way. There isn't a presumption that what takes place in a place which is the public have access to is not private. It's simply not that simple. And because a judge started with that presumption, we say that's where he then proceeded to go wrong. Now, the crux of the decision is shortly set out well, first of all, actually, I'm going to just deal with some of the relevant facts. It's page 65, paragraph 32, the relevant facts are set out. If I could take you to subparagraph 10, which is something that's probably been dealt with in argument already, but I just want to identify where the point is made in the judgment appealed. You see, it's subparagraph 10. The claimants were, however, aware they'd become the target of photographers. They made the trip to the restaurant and chose what to wear in that knowledge. We say that cannot weigh against the claimant in assessing whether they had a reasonable expectation of privacy or not. We say that amounts to victim blaming. They should not be expected to interfere with how they conduct their family holiday, because on the 27th of December they were subjected to very serious harassment and stalking by those four photographers.
Right, so you say that that was not a relevant fact?
Yes. And then subparagraph 12. There's no evidence the claimant taken steps to exercise an autonomous choice to keep their physical appearance private. Photographs of them are already in the public domain before the 28th of December. They have appeared in public to give evidence before a parliamentary select committee. Now, that's just a reference to something said by Mrs. Stoute at the very end of her second witness statement. It's not for the claimants to prove Well, first of all, I'm not quite sure what the expression autonomous choice to keep their physical appearance private means. They're entitled to appear in a public place or a private place as they want to appear. The issue is whether people are entitled to take photographs of them covertly or otherwise and publish those photographs to hundreds of thousands of people. It was in fact the second claimant who appeared before the Parliamentary Committee, not the first claimant. We say, if it needs to be said, it's startlingly obvious that when Mrs. Stoute goes about her behaviour as a businesswoman or attends to give evidence on weighty matters to a parliamentary committee, that she's not dressed in the way she was dressed in that photograph in issue on the beach. So we say that that point goes nowhere. Now, the crux of the reasoning of the judge is set out in paragraphs 33 and 34.
Just before we move on from paragraph 32, I think one of your submissions is that the judge did not bear in mind at all that it was a family activity. Doesn't he do that in subparagraph 7?
Yes, I immediately have to concede that. He refers to a private activity regarding attending the daughter's birthday celebration. But that doesn't come into his reasons in paragraphs 33 and 34. He doesn't explain why that isn't what we would say ordinarily be a very strong factor in favour of a reasonable expectation.
Yes, I see.
Now, my lords, are paragraphs 33 and 34 fresh in your mind? Or would you like a moment just to remind yourselves of them before I make submissions?
That would be helpful. Yes.
So, starting with the beginning, the second sentence, paragraph 3, he says, a person may retain a reasonable expectation of privacy in respect of information is obtained about them when they were in public. But we say again, that's the wrong starting point. That's a presumption that events in public cannot be private. But then he gives a series of examples of what has to be said, a new principle of law which he's invented, in that where something takes place in public, there needs to be an additional element, if you like, to put it back in the box of privacy. Now, one of those matters not mentioned is the fact that this was a family event. And we say this takes no account of the principles made absolutely clear in Weller, Murray and von Hanover, that privacy can apply to quite ordinary quotidian events, going to a cafe, going to a shop, particularly if they are family events. The judge is looking for too serious matters here and forgotten about the conduct of a private life is often mundane. But even though it's mundane, it ought in certain circumstances to be protected. And really the crux of his mistake, in the way he's emphatically invented this principle and forgotten about the Murray factors and all the circumstances of the case, is really that very last sentence of paragraph 33, where he says it follows that there is no general reasonable expectation of privacy in respect of information that is paid to anyone who happens to be in the same place at the same time, which we say is clearly wrong on the Court of Appeal authorities and picks up on the point made by Lord Justice Warby that just because you don't have reasonable expectation of privacy in regard to someone standing nearby you when the photograph is taken, that doesn't mean you don't have a reasonable expectation of privacy in regard to mass publication of those images. Now, paragraph 34, second sentence, that's where he refers to the demonstrative and performative element of their arrival. Now, clearly, there's no mistake in law in that, but we say it's overreaching to say that because someone travelled from point A to point B, from a boat to a beach in a holiday resort by jet ski, that somehow that means what might have otherwise been a reasonable expectation of privacy is lost. And we do emphasise on the facts that this is very much an after-the-event argument cooked up by the defendant, because the articles themselves don't show public photographs of them on a jet ski. It just said they arrived at shore by jet skis. His conclusion they're likely to draw attention to themselves. Well, the undisputed evidence was there were only 90 or so people at the restaurant, and the beach itself where they landed was in fact deserted, and the restaurant was nearly a football pitch in length away from them. So the judge concludes there's no additional element as he understood it, but doesn't deal at all with the family activity. And of course, Article 8 refers to protection of family life. And then again, he says the information that's contained in the photographs is simply what any person present at that place at that time would have seen. And again, we say, for reasons already explained, that is simply plain wrong and led him into error. It meant the exercise of his discretion. I'll just call it a discretion for the shorthand for the general decision-making process. Simply could not be done properly, and this court needs to exercise the discretion afresh. Now then he talks about...
Well, I think at this stage this is evaluation rather than discretion, isn't it?
Yes.
Yeah.
Yes. It's just, is it plain wrong or isn't it?
Well,
or did he proceed on the wrong
for your
basis?
purposes to show an error of principle,
Yes.
and hence your arguments about, for example, the additional element.
Yes. Now then he does quite properly deal with Princess von Hanover, and quite rightly he does consider the degree of targeting, stalking and so on and so forth. So it's in his consideration. But what he does is, we say, is he elevates the facts in the von Hanover case to a principle of law and says, well, the claimants in this case, Mr. and Mrs. Stoute, don't succeed because what happened to them isn't as serious as what happened to Princess Caroline. We say that that's not a proper basis for proceeding. You've just got to look at the targeting and the behaviour over the 2 days itself and decide to what extent, if any, it contributed to a reasonable expectation of privacy. We say if an additional factor is needed, in addition to the fact that this was a family holiday and a family event, then the appalling behaviour on Thursday, followed by the covert photography which took place on the following day, the day of the birthday, is ample. That clearly is the type of press intrusion causing the result referred to in von Hanover, a sense of unease, causing an interference with conduct of one's family life of itself. And of course, again, all cases are different. But I did take you to the case of Murray, where you had stalking harassment of a similar order as took place here. And the order was very serious. 4 people were employed, a jet ski operative, the man on the back of the jet ski, the 2 female paparazzi, to stake out the claimant's house on the 27th of December. And then you've got the activity on the 28th, where the whole group were photographed. And one clear point about this is that numerous photographs were taken, as the defendants admitted in correspondence. This was a group intermingled with adults and children. Those photographs also included children. Clearly, those particular photographs weren't published, but the court is entitled and should look to the degree of activity by the paparazzi. And as we said before Mr. Justice Johnson, we say again, and it's recorded in his judgment, this sort of behaviour, stalking a group which includes children, photographing adults and children, going about what might be called a mundane activity, enjoying their holiday, is positively creepy and really does militate further in the court finding that this is an important circumstance.
What was the nature of the argument before Mr. Justice Johnson about the points that you're making about the last sentence of paragraph 33 and the 7th line of paragraph 34?
Well, it's the arguments made, I think, broadly the same authorities were put before him, and the submissions on the law were broadly the same. Of course, inevitably, with more time, they've been improved in this case. But Campbell was relied on.
Yes, but was there close attention paid to the difference between the people on the beach and the restaurant on the one hand and the great British public on the other hand?
Yes, most definitely.
And how is that found either in this judgment or in some document that was before the judge?
I haven't got a copy of the skeletons. It's not dealt with in the judgment.
I'd like to have some light shone on that over lunch, if we may. Because, I mean, you see, the sort of activity that is going on here is not like Mr. Mosley's activities, which would not be the sort of activity that he'd want the other people on the beach or the people in the restaurant to be viewing. Even 90 strangers would be too many for that.
Yes, that's on the far end of the spectrum, if you like.
Whereas here the information appears to be the sort that doesn't really matter if 90 people see it. What matters is if 900,000 people see it.
Yes.
I see there's something said in Tugendhat about that, but why? Why is it all right if Mr. Bloggs happens to be holidaying in Barbados, that he should know about it, but that if Mr. Bloggs happened to stay at home, he shouldn't?
Well, it
surely goes to the impact on the claimant. It's not conceptual in terms of how large the public was at any one moment. I mean, it's surely where you might say this makes a big difference is because the impact on me of national publicity is different from the impact of local publicity or just local people seeing me. But it's not. I mean, if something's private, it's not just private to certain people. That's what newspapers are there for, is to inform people of what's out and about, so they don't have to go and find out for themselves, which they can't. So I can quite understand that if somebody's life was destroyed or their private life was severely interfered with by the fact that it's all over the tabloids, that's a very serious matter. But I'm not understanding the conceptual difficulty between in identifying what is and what isn't private information, just on the basis of how many people are going to see it. It comes into the balancing exercises I get, but it's not conceptually different.
It's on the authority. The authorities are absolutely clear.
Right. And which one, to remind me, because we went for a tour through the whole lot, which one particularly makes this point? That, tabloids is one thing.
Not tabloid. Well, Murray were photographs of tabloids.
Yes.
But it is Murray.
Right.
Where they talk about the wrong here isn't so much people seeing someone in the street, it's the dissemination of the photographs. Right. Miss John is just looking up the reference.
Well, that will help you. Thank you.
Well, firstly, to answer your earlier question about to what extent was it put to Mr. Justice Johnson there was a difference between what people saw on a beach and what people saw in a tabloid. That's mentioned in paragraph 23 of the judgment,
Right.
at about the 10th line down, where it says there is, he says, a difference between.
Next.
Yes,
Paragraph
pardon me,
23 of the judgment.
digress.
Right, so you made that point and it wasn't answered, you say.
Yes, from the judgment. I did. You can see I did make the point,
Yes.
and the judge positively disregarded that and said that all that matters is a reasonable expectation to those other people on the beach. And we say that feeds into the first error in law that we identified at the beginning of this section of these submissions.
Right. Well, if you were going to look to see what lay behind that,
I was just trying to.
It found its way into the judgment, yes. Now you're going to take us to Murray.
Yes, I'm
Right,
just
good.
looking for it now.
Thank you.
Paragraph 17 of Murray,
Thank you.
page 226 of the authorities bundle. I think there's a better quote, which I don't have at my
That seems to be.
fingertips from
I
another
see why
case.
you've mentioned paragraph 17. It seems to be more about the degree of interference caused by continual stalking, right? And it's not making the point at that stage that there's a difference between the people on the street and the world at large.
There's page 408 of the bundle. There's an extract from Law of Privacy in the Media.
Paragraph.
That's paragraph 5.139, the last sentence. As Lord Justice Laws observed in the case of Wood, it's clear that the real vice in Campbell and also the Von Hanover case and Murray was the fact of the threat of publication in the media and not just the snapping of the shutter.
Well, can we, I mean, by all means, I don't want to interrupt the points that you're making, but you've pointed out that you made a submission to the judge which he may not have dealt with.
Yes.
So, is there anything that Mr. Wolanski says about it? I'm just really interrogating what the legal basis underlying that submission, while quite accepting that it's bound to be a feature of the case, and it may in particular be relevant to the attributes of your client and their resilience and so forth that would be matters of importance in making these judgments.
Yes.
But
I'm afraid
whether it goes to whether this is private or not is something that I, at the moment, entertain doubts about.
Well, could I stay with that point, the distinction between being seen on the beach and being seen by the world at large? And that really depends on the features of photographs, which are dealt with in the case of Douglas. A photograph reveals a lot of personal and private information of people. And it's implicit in the authorities that publication of photographs of people, when they're not expecting to be photographed, are published to the world at large, can be humiliating and upsetting to them. Now, it's also the point that one aspect of this case is the fact that the claimants were dressed for the beach. Mr. Stoute was in a t-shirt and shorts. Mrs. Stoute has set up in the skeleton argument. Much more was being revealed.
Well, they're dressed for a beach and for a beach restaurant.
Yes.
Yes.
Now, it's just humiliating to have photographs of oneself published at large to members of the public in this form. It's an intrusion. It's the fact the private activity has been invaded. And again, the authorities are very strong on the fact that mundane family activities can be protected. You could say the same about Princess Caroline. Why should she care that she's photographed riding a horse or going to a tennis club? You could say the same about the case of Weller and Murray. Why should they care, particularly given that children in both instances could not possibly experience any distress? But there is simply a reasonable expectation that people will see you in the vicinity, where there's a reasonable expectation that people who are not in the vicinity will not see you. And that's the problem with this kind of photography. It's where the camera is in effect acting as a sort of peeping Tom. And it's seeking to capture images on a beach, which we say are private images, and then publishing them to the world at large. And as Douglas says, there's very much a voyeuristic aspect to the publication of that sort of image. So that we would say is the distinction on first principles, and the distinction highlighted in the authorities. And it's taken as a matter of almost assumed in the authorities that it will just be embarrassing to have photographs of one doing a private activity published to the world at large, because once it's published to the world at large, the private bubble has been broken. The subject of the photograph has lost their privacy. And that's why there is, in fact, a very strong distinction between being seen on a beach and having photographs of you on a beach, attired for the beach, published to the world at large.
If you're looking for some law to support the idea that publication and the creating of a permanent record may be the vice, it may be, excuse me, it may be paragraph 122 of Campbell.
Oh, I'm grateful for that.
Where the European Court is recorded as pointing out that private life considerations may arise once any systematic or permanent record comes into existence of such material from the public domain.
Yes.
I don't know if that's what you had in mind.
It's exactly what I had in mind, and it's a word I keep using. The use of the word dissemination, paragraph 38, next to indented letter B. It's whether the public's right to information justified dissemination of a photograph taken without authorization. Because the key point about dissemination, sorry to repeat myself, is that the privacy bubble is broken. What was private is now no longer private, and it's objectionable for that reason. Of course, people like Mr. Mosley will have a greater reasonable expectation given the activities involved, and they took place in a basement where the public were excluded. But just because you have extreme examples on that end of the spectrum doesn't mean that part of the spectrum of where someone can have a legitimate, reasonable expectation of privacy shouldn't or should encompass the type of activities before this court.
It's not really.
I'm sorry.
I was going to say, it's not really a case of what was private is now public, is it? It's rather a case of what was public in one way is now public in a much wider way. I mean, it was public that they arrived on a public beach dressed as they
Yes.
were for members of the public to see them. But your complaint is that it's now therefore
Public and therefore not,
everybody to see forever.
yes, and therefore not private. And it's, those are broad concepts reflected in authorities, but one can also see practical examples of this, and particularly Mrs. Stoute's evidence. She's a businesswoman. She wants to go to business meetings. She knows very well, as people do now, people Google before they meet them in business meetings or elsewhere. By reason of this, she's lost a degree of her dignity. She wants to go to a business meeting wearing a business suit, be taken seriously. She doesn't want effectively a holiday snaps of her to be taken and made permanently available on the internet via a Google search for her name.
Passage at 122 of Campbell is to do with the balancing exercise. Is it not?
Well, the balancing exercise actually wasn't. Well, I see what you mean.
I'm not
right,
saying that
balancing
your
rights
proposition is
issue.
wrong. I'm
Yes.
just at the moment trying to anchor it in
Yes.
something that says it in terms. I'm sure if there was something that says it in terms, you'd have pointed that out to the judge and to us. You're as we're putting together this submission.
Yes.
From,
Well, it must be, if it's relevant to the balancing exercise, it must be relevant to the first question, reasonable expectation of privacy. I should emphasise, Campbell, as I said at the beginning, is the wellspring. It's only as the case law is advanced there's been a clear delineation between the question one, the reasonable expectation, question two, the balancing exercise. And we say it's obvious as a matter of first principle that the scale of publication must be relevant to the reasonable expectation of privacy, because the reasonable expectation of privacy must be greater for private information not
well,
to
it
be
comes out,
disclosed.
it's a Murray factor. It's the nature of the intrusion. I mean, that's one of the
Yes.
Murray factors, as you've described them, is the nature
Yes.
of the intrusion. So clearly, I mean, sometimes people send around information to a WhatsApp group or a work
Yes,
email group. This is an intrusion of a different
yes,
kind. I mean, they may both be equally
yes.
difficult.
You have a reasonable expectation of privacy that people in your WhatsApp group will keep matters private depending on the circumstances.
No, I was rather putting it the
You
other
have-
way, namely that if everyone's a WhatsApp group and somebody then puts up information about one member of the group which is private,
Yes,
that has a particular sort of effect. Similarly,
Yes.
if something goes on an email ZZ
Yes.
group, it has a particular effect. This is a different sort of particular
Yes.
effect, namely national broadcasting.
So, another passage in Murray which is relevant to this discussion is paragraph 32. I mean, there are in fact a lot of passages in the authorities which are consistent with the submission you're making, I think. But in paragraph 32, which is page 231 of the authorities bundle, the master of the rolls giving the judgment of the Court of Appeal cites Lord Hoffman as drawing an important distinction between the taking of the photograph and its
Yes.
publication.
yes, yes. I'm grateful for that.
Thank you. And that then comes, I think, if I'm right, if one was linking it to the Murray factors, into the nature of the intrusion.
Yes. Just the nature and purpose of the intrusion.
Yes.
It's difficult to actually set out what the purpose of taking photographs of this is. It's a type of material which Baroness Hale talks about in Campbell. It's a type of material talked about in various authorities. It's at the very bottom of the order which the court will protect freedom of speech. It's tittle-tattle. It's photographs of people dressed for the beach or on a beach. There's no real purpose of it at all, except to say, really, look at them. Look at what they've been doing on holiday. You can't really, it's not a very well expressed phrase, but it's really no higher than that when looking at it from the perspective of the Sun on Sunday. There's just no value to it at all, particularly compared to the intrusive nature of the information as published. So those are the submissions regarding why and how the judgment went wrong. We invite you to exercise, if you're with us, that decision cannot stand. We invite you to exercise your discretion afresh to find that there was a reasonable expectation of privacy. I've really set out the reasons for that in the skeleton and during my submissions. I won't repeat them now. For obvious reasons, Mr. Justice Johnson never had to carry out answer question 2, the balancing exercise. But if you're with us on reasonable expectation of privacy, we say there's nothing on the other side of the scales. Section 12.3, the third question, are we likely to succeed at trial? Well, the answer must be an emphatic yes on the material before this court. Now, the fourth question concerns really the discretion a court always maintains or retains as to whether or not to grant an injunction, even though the merits are made out. Mr. Justice Johnson considered the fact there had been prior publication as a barrier to granting the injunction to prevent future publication. Now, for reasons expressed in PJS, which I've gone to, and in Douglas, particularly in regard to photographs, we say there is still something worthwhile being protected. And we particularly pray and aid the judge's finding that republication of the photos is likely to take place. And of course, an injunction would achieve something very tangible, because pending trial, it would prevent those photographs to be continued to be published and to be Googled on the Sun on Sunday's website. And in weighing up the balance, we say, well, look at, what more can the Sun on Sunday achieve? It's had its mass publication. Future publications are likely to be targeted, by which I mean they're going to be targeted by people searching for information about the Stoutes. So we say that militates very strongly in granting the injunction. There's still something to protect, so it should be granted in that respect. And lastly, the point we make is this one, which it really arises on the particular facts of this case. If you find that an injunction should have been granted, it therefore follows really that an injunction should have also been granted on New Year's Eve when the application came before Mrs. Justice Heather Williams. If it's found that the court erred and didn't grant an injunction, then that must be a factor militating, that caused the material to enter into the public domain. And we say that should now not be used as an argument, or should be tempered for that reason in deciding whether public domain is, as the defendant says, a trump card to prevent the imposition of an injunction now. My lords, unless I could be of any further assistance.
Well, what do you say is the judge's finding about further publication? I'm looking at paragraph 38, and the concluding sentence is real prospect that the defendant will publish the material that the claimants seek to restrain, but the preceding sentences are about further photographs, whereas what you're wanting to do is to get taken down the photograph that has already been published, which seems a bit different. Can you clarify that at all?
It's all I can say is that the application by then was just to prevent the publication of photographs in issue before you today. But it's part of our submissions today, and I think part of our submissions then, that if an injunction is granted, that will have a salutary effect on other newspapers' decisions whether to publish other photographs. That wouldn't be an injunction itself. It would just be a disincentive.
I mean, an injunction wasn't granted, and no further photographs have been published. And the judge said at 37, well, the fact I'm not giving an injunction doesn't mean the defendants have the opportunity to act with impunity. But nevertheless, there don't seem to have been any further photographs. That's right, isn't it?
That's correct.
Okay.
What do you say about what the judge says at 41, which is he accepts your submission as an injunction can be granted to restrain further misuse of private information, even if the information is already in the public domain. But he says in the particular circumstances of the present case, he thinks the balance falls against in favour of not granting an injunction pending trial.
Yes, well, he was wrong on that part of his reasoning for reasons expressed towards the end of our skeleton argument. He considered that argument on the basis that the claimants had succeeded in answering questions 1 to 3 in their favour. Therefore, in effect, it was based on the counterfactual that there was a reasonable expectation of privacy and that publication ought to be prevented. But then when he applied his reasoning in such a way that he didn't take account of that, because once it had been concluded there was no reasonable expectation of privacy, there was no balancing factor, and the claimants were likely to succeed at trial, that would be it. But what he did, he started considering, well, how unfair it would be on the defendants in weighing up what he called the balance of convenience on the defendants if the material was still published, given that the claimants might fail at trial. But of course, that's not a proper consideration, because if a claimant satisfies section 12.3, the courts found that, in fact, the claimant's likely to succeed at trial.
Thank you very much, Mr. Banks. Yes, Mr. Orlando.
Lords, I'm going to address the points as follows. First of all, I'm going to say a few words about the test that needs to be applied on appeals from decisions of this kind. Then I'm going to address you on the case law concerning the law of privacy regarding photographs taken in public places. And finally, I'm going to respond to the claimant's, the appellant's attack on the judgment. So dealing first of all very briefly with the test on appeal, this court should only intervene if it finds the judge has erred in principle or reached a conclusion which was plainly wrong, or put another way, was outside the ambit of conclusions which a judge could reasonably reach. And that's because he carried out a balancing exercise which is akin to the exercise of discretion. We've given the citation for that in our skeleton argument. It's also in the authorities bundle. I needn't take your lordships to it in Weller at tab 8, paragraph 57, page 265. It is a high hurdle. It's been described by this court as a significant hurdle for the appellant to overcome. We say it is not overcome, that the appellant has failed to demonstrate that the judge has either erred in principle or has reached a conclusion that was plainly wrong. Moreover, I don't think it was even suggested he had omitted any relevant fact from his consideration of the balance or taken into account any facts which he shouldn't have taken into account. Next topic then is the case law concerning the law of privacy. regarding photographs taken in public places. We say three central propositions can be divined from the cases. First of all, where photographs are taken of adults in public places which do not convey obviously private information, but rather which show the person engaged in mundane or routine behaviour, there will, in general, be no reasonable expectation of privacy. Secondly, the law will not intervene in respect of the publication of trivial or anodyne
Can you just go a little bit
information.
more slowly?
Secondly, the law will not intervene in respect of the publication of trivial or anodyne information. And that applies whether the information is contained in written text or in photographs. And third and finally, the position is different when it comes to images of children. Lord, a good starting point is the extract from Gatley, which the court will find at tab 13 of the bundle of authorities, and in particular paragraph 23.013. Which your lordships will find at page 401 of the bundle of authorities. Does the court have that? So that paragraph starts with the second of the propositions, namely that the law will not intervene in respect of the publication of trivial or anodyne information. And there's a citation there from Mr. Justice Eady in A and B. This, says the author, accords with the general understanding that interference with private life must be of some seriousness before Article 8 is engaged. And we'll see how that is explained in the McKennick case when we come to it. Then further down that paragraph, starting, there has also been debate.
Yeah, but you've skipped a rather important paragraph, which is where the editors say that nothing can be presumed.
Nothing can be presumed.
And in some circumstances, even ostensibly trivial information can warrant a
Absolutely.
reasonable expectation of privacy.
Your lordship's right.
So these questions are always fact sensitive.
They're always, absolutely, absolutely. The following paragraph, perhaps I can invite the court to read that, and particularly the second half of the paragraph.
Yes?
So that echoes our first proposition, as I explained it a moment ago. And then finally, before we move away from Gatley, paragraph...
Well, just before you go on, what do you say to the suggestion at the end of this paragraph, it's 403 in the bundle, that English law is out of step with the developing jurisprudence under the Convention?
There is superficially a tension between Caroline and Campbell, and of course, if that's the case, then this court has to follow Campbell. However, the position has become clearer, we submit, since the subsequent decision of the European Court in Lillo-Sternberg, which makes clear that this is very much a fact-sensitive exercise, that the Court of Human Rights was not, in Campbell, laying down any kind of hardline principle in respect to the publication of photographs in public places. So if one looks at the subsequent authority of the European Court of Human Rights, it's clear that, in fact, English law is in step with European authority, whatever the position may have been immediately after the handing down of Campbell. If you like, Lillo Stenberg has brought the two back in line.
Thank you.
Before we move away from Gatley, paragraph 23013, 23007, which is on page 400, deals with the position of children. This is our third proposition. And I'd invite your lordships to read that paragraph. Moving then to Campbell. Campbell is still the leading authority on the topic of the publication of photographs taken in public places in this jurisdiction. Now, Campbell was a slightly complicated case on the facts, of course, because it concerned, first of all, not just the publication of photographs, but also the publication of the articles which accompanied the photographs. And I'll come on to the significance of that when we look at the judgments. It was also complicated by the fact that the claimant conceded that the newspaper was entitled to publish information about the fact that she had taken drugs and that she was receiving treatment for the taking of those drugs, and that she was receiving treatment through therapy at Narcotics Anonymous. So all of that was conceded to be legitimate. It was only the additional factors which remained.
So just to test that out, is it right that had there just been an ordinary publicity still of Miss Campbell attached to the text, that wouldn't have that would have been an entirely different situation.
Sorry, what?
If the picture
Yes.
had just been one of those pictures of Miss Campbell,
Yes.
Not one in the context of the street scene,
It would have been.
Then they wouldn't have been where they were. The case
Absolutely, and in fact, and we'll see this explained in the speeches. But had the very same picture of Miss Campbell walking into a building been published on its own without any kind of accompanying article, or had the claim been restricted just to the picture, the outcome would have been different.
Right. So it was the particular combination of the two.
Correct.
That's the point you're making.
It is the point, and it's as we'll see, it's in our submission a fundamental point of distinction between Campbell and the current case, where.
Well, can I just test that? Because do you go so far as to submit that in assessing whether there's a reasonable expectation of privacy in respect of a photograph which is published in the mass media, one strips out of account all the context provided by the article within which that photograph is published?
It depends on how the claim is framed. So that most claims of this kind, privacy claims, will be claims in respect of text, and they may encompass photographs which are used to illustrate the text. So that would be the standard privacy case. This is a very, very unusual case because the claim is confined to publication of the photographs. And
well, it's not that unusual because that's the scenario in both Murray and Weller. I appreciate those are cases involving children.
It is.
But in both of those cases, it was purely about the photographs.
It is. Those cases are the two where it was just photographs.
And you know it wasn't just the content of the photographs because you had to look to the text to find out who the photographs were of.
That's true. That is true.
So is it your submission that the text is to be disregarded?
In this case, it is. Absolutely, it
Why?
is. Because no complaint is made about it at all in the case.
So what?
Well, because by the time the particulars, the claim form was issued and the particulars of claim drafted, the article had been published. The first of the two articles had been published. So it was open to the Stoutes to make complaint about the content of the first article. and indeed the second
Yes,
item.
but they're not complaining about the text. They don't say there's a misuse of our private information in the information included in the text. Their complaint is about the publication of the photographs, and they say the text provides context, e.g., because it tells you who the subject of the photographs are. And do you seriously dispute that?
Well, it's not the way they've put their case. It's not the way they've advanced the case.
How would any viewer of The Sun on Sunday know who the photographs were of without being told by the newspaper?
Your Lordship has obviously a good point, but it's not the way the case is presented. If for example...
But I'm sorry, it's implicit in every word that Mr. Bennett has said to us this morning that the gravamen of his argument is all about that these photographs were of his clients. He wouldn't be here otherwise.
Insofar as the complaint is of photographs that identify his clients, of course that's right. But
So therefore you have to look at the text to find out who they are.
That's true. Your Lordship's right to that extent, but insofar as the information goes beyond explaining who they are, and for example talks about what they were doing or what they were, other features of the text, no complaint is made.
No, the explanation has to go a little further, doesn't it, than who they are, because if members of the public are simply told this is a photograph of Mrs. Stoute, they're not going to know who she is. So you've got to tell them something about why she is a potential, considered by the editor to be a potentially newsworthy person. And it's because of the making a lot of money in the pandemic. So you've got to have at least that much text, haven't you, in order to make sense of the claim?
Maybe, yes, to make sense of, in a sense, the photograph, but that is not the subject of the complaint. That's very important, because in Campbell it was. I see the time.
Yes, I'm sorry, it's probably better that you take us through Campbell after lunch break. We'll start again at 2 o'clock. Thank you.
All right.